Picture this. You're driving home, normal night, green light, then out of nowhere, headlights drift into your lane and everything explodes. Airbags, glass, that ringing silence in your ears. And while you're still trying to figure out if you can feel your legs, you hear someone say it. He was drunk. Now the obvious question is, can you sue the drunk driver? Yes. But here's the gut punch that most families find out later. The drunk driver may not have real insurance, real assets, or even real money. So even if you win on paper, you lose in real life. So here's the question that actually changes outcomes. Where did he get the drink? Because in Illinois, there are situations where the bar or restaurant or liquor store that served them can be held financially responsible for what happened next. I am Jason Marker, a personal injury lawyer here in Illinois for over 25 years, and this is what we're talking about today. When a bar can be on the hook for a drunk driving crash, what you have to prove, what evidence matters, and the big limitation almost nobody mentions until it's too late. All right, let's get into it. In Illinois, the legal backbone is called a Dram Shop Act claim, which is found under the Liquor Control Act. In plain English, it gives an injured person a right to sue a licensed alcohol seller if that seller, by giving or selling alcohol, causes someone's intoxication, and that intoxicated person then causes injury or property damage. Two things in that sentence are everything. First, this is about licensed sellers, bars, restaurants, liquor stores, and similar businesses with a license. Second, this is not the drunk driver suing because they ruined your own life. The statute blocks claims for the intoxicated person's own injuries and their own losses of support or society claims. So the Dram Shop Act is designed to protect the public, not bail out the person who chose to drive drunk. There's always a huge timing issue, and we'll have to come back to it. But keep this in your head for now. Dram shop cases in Illinois have a 1-year deadline. If you miss it, the claim is barred. Now, the 4 boxes that you must check. Here's the mistake most people make. They think he drank at the bar, then he crashed, so the bar pays. But that's not how this works. To hold a bar responsible, you have to connect the dots with proof. Think of it like 4 boxes. If you can't check all 4, the case falls apart. Box 1. The alcohol came from that business. You need to show that the bar or the liquor store actually sold or served alcohol to the person who caused the crash. Not a rumor, not vibes, proof. Box 2, that alcohol contributed to the intoxication. It's not enough that they visited the bar. You have to show that they drank there, caused or contributed to them being intoxicated. Box 3, the intoxication caused the harm. You've got to show that the crash or injury happened because the driver was intoxicated. Box 4, real damages happened. Someone was injured, someone died, or property was damaged. No damages, no case. Now let's make that real. If someone spends 3 hours at a bar, is served around after, stumbles out, gets behind the wheel, runs a red light, and hits you, those boxes can line up pretty quickly. But if they had 1 drink at a bar, then went somewhere else and kept drinking, now the chain gets messy. That doesn't mean it's impossible. It means that the proof has to be clean. Now let's talk about who this usually applies to and who it usually does not. Most dram shop claims target licensed businesses, bars, restaurants, nightclubs, sports bars, event venues with license, packaged liquor stores, even some places people forget about, like a convenience store with a liquor license. What about a private party? In general, Illinois Dram Shop liability is designed for the liquor business, not your neighbor pouring beers at a barbecue. Courts have repeatedly held that social hosts are not liable under the Dram Shop Act for serving adult guests who later get hurt or hurt someone else. But there are exceptions and related rules when minors are involved. For example, the statute includes language creating liability for certain adults who pay for a hotel or a motel room knowing it will be used for underage drinking that causes intoxication. So the simplest rule to remember is this: dram shop claims usually live in the world of licenses and alcohol as a business. Now, the part that wins or loses the cases, evidence and timing. This is where people lose good cases. Not because the law is unfair, but because the proof disappears. Surveillance videos get overwritten. Receipts get purged. Employees quit. Memories turn into shrugs. If you think a bar may be involved, the real game is building a timeline. Here is what a strong timeline looks like. When did the driver arrive at the bar? What did they order and how many? Who served them? When did they leave? How much time passed before the crash? What did police observe at the scene? Did the driver admit that they had been drinking? That timeline is built with boring stuff that becomes priceless later. Credit card receipts and bar tabs, point of sale records, surveillance footage, witness statements from other patrons and staff, social media posts, selfies, stories, timestamps, police reports, field sobriety tests, breath results, body cam footage. Sometimes the strongest piece of evidence is embarrassingly simple. The drunk driver tells the officer, "I just left that bar." Now, let me give you a twist that happens all the time. A family is hit, injuries are serious. Everyone assumes the bar is an easy target. Then the investigation shows that the driver had 2 drinks at the bar, left, and drank heavily somewhere else. Suddenly, the case is not about outrage, it's about chemistry, timing, and proof. Can you show that those 2 drinks at that bar actually contributed to the intoxication that caused the crash? Sometimes yes, sometimes no. That's why evidence matters so much. Now, for the twist most lawyers put in the fine print, the cap, we need to talk about the money because this is where expectations get wrecked. Illinois Dram Shop claims have a statutory cap for recovery, and it changes every year based on the Consumer Price Index. Here are the limits for judgments or settlements awarded on or after January 20, 2026. For an injury for property damage, the recovery cannot exceed $90,411.55 for each person having damage. For loss of means of support or loss of society, the recovery can't exceed $110,503, and that cap goes all the way, as the statute says, to claiming support or society for the injured or the deceased person. 2 important clarifications. 1, those numbers can go up or down each year, so always check the current limits before you make big decisions. 2, this cap does not mean that your total case is capped. It means the dram shop portion is capped. You can still pursue the drunk driver and other responsible parties under normal rules, depending on the facts. So if you're thinking, wait, my hospital bill alone is more than that, you're not wrong. That's exactly why these cases are often about stacking responsibility and we're stacking parties and insurance coverage. Now let's tackle a question that I hear all the time. Do you have to prove that the bar knew the person was drunk? A lot of people assume dram shop cases work like a negligence claim, where you must prove that the bartender saw obvious intoxication and kept serving anyway. Illinois is different. The Dram Shop Act is a statute, and it's not predicated on a negligence theory the way many people think. In practical terms, that means you're not always fighting over what the bartender knew in their head. You're proving causation, that the business sold or gave alcohol that caused intoxication, and that intoxication caused the injury. That said, evidence of visible intoxication still matters a lot because it makes your story believable to the jury and it helps connect the dots. Slurred speech, stumbling, loud, aggressive behavior, falling asleep at the bar, getting cut off, being helped to the door. Even if knowledge is not the technical element, the human reality is this: jurors understand overserving when they see it. Now, how do bars defend these cases? Bars and their insurers do not casually pay dram shop claims. They look for any break in the chain. Here are the most common defenses. First, you cannot prove service. No receipt, no video, no witness, just a guess. Second, it didn't happen here. They drank somewhere else before or after. Third, the timing does not work. A long gap between leaving the bar and the crash raised questions about what happened in between. Fourth, the intoxication did not cause the crash. They blame speed, weather, a mechanical issue, or even the other driver. And sometimes there's even a weird one people do not expect, that the injured person actually contributed to the intoxication. This is a doctrine called complicity that can bar recovery in some situations. It's not common in a random DUI crash victim case, but it matters in scenarios where someone's buying rounds, pushing shots, or helping get the person drunk. Now, let me give you a clear example so you can actually see this. A woman goes to a neighborhood bar, say in Springfield, Illinois. Over 2 hours, she orders multiple cocktails. Other patrons notice she's loud, unsteady, dropping her phone. Staff keeps serving her. She leaves and drives straight home. 3 miles later, she crosses the center line and causes a head-on crash, seriously injuring another driver. Now, the injured driver's lawyer builds the timeline. Witnesses confirm heavy drinking and visible impairment. Receipts show multiple drinks in a short window. Police report documents intoxication at the scene and a direct statement about leaving the bar. No evidence of additional stops between the bar and the crash. That is a dram shop case that makes sense, not because the bar physically drove the car, but because the proof ties the alcoholic service to the intoxication and the intoxication to the injury. So what should you do if you think a bar might be involved? If you or someone you love was hit by a drunk driver, here is what I want you to do in order. First, get medical care, always. Second, make sure law enforcement is involved and you get the report number right away. Third, write down everything you remember while it's fresh. Exact times, what the driver said, any bar name you heard, any witnesses who mentioned where they were drinking or what they were doing. 4, preserve evidence fast. If you know the bar, do not assume footage will exist for a month. In the real world, it gets overwritten. 5th, talk to an attorney who has handled Illinois Dram Shop Act cases before. The 1-year deadline is real, and waiting can quickly kill a claim, even if liability is obvious. So when can a bar be held responsible for drunk driving crash in Illinois? When you can prove the bar sold or served alcohol that caused the driver's intoxication, that intoxication caused the crash, and real damages happened, that's when you have a case. And even when you prove it, you need to understand 2 realities. There's a 1-year filing deadline, and there's a statutory cap on what bars actually have to pay. If you want to be ready for the worst case scenario, go watch the next video. 4 steps you must take to win your wrongful death claim. Because when tragedy hits, speed and evidence are not nice to have. They are the difference between getting answers and getting shut out. I hope you found some of the information in this video helpful, and I'll see you on the next one.